In 1818, a man accused of murder stood before an English court and did something that shocked all of London. He didn't call a witness. He didn't offer an alibi. He threw down a leather glove at the feet of his accuser and formally demanded a trial by combat, a fight to the death, to settle the case once and for all in front of a watching crowd. And the court, checking its own laws with growing disbelief, discovered something almost nobody expected. He was completely, legally entitled to do exactly that. Here's the part that should genuinely unsettle you. This wasn't some obscure loophole unearthed from 1,000 years earlier by a clever lawyer. Trial by combat had simply never been formally removed from English law. It had been sitting there, fully legal, silently, for centuries, waiting for someone determined enough, and desperate enough, to actually use it. Let's put you in the position of William Ashford. Your sister, Mary, has been found dead under suspicious circumstances. The man everyone in your village suspects, Abraham Thornton, a large, physically imposing man, stood trial for her murder, but the jury acquitted him, the evidence falling just short of what the court required to convict. Under an old and largely forgotten law of the time, as the victim's brother, you still have the right to bring what's called an appeal of murder, a separate legal path that lets you personally pursue the case yourself, even after that earlier trial reached a different outcome. You believe justice is finally within reach a second time. And then Thornton does something you never anticipated, something so old that most lawyers in the courtroom had never seen it invoked in their entire careers. He exercises an ancient right buried deep in the law. He formally challenges you, personally, to trial by combat. Whoever wins the fight is legally declared to have told the truth. Whoever loses is guilty, whether or not they survive the encounter at all. You are not a large man. You are not trained to fight, and you have never held a weapon in anger in your life. Accepting this challenge is not justice. It is a death sentence with legal paperwork attached to it. And under the exact letter of the law being invoked against you, refusing to fight means you formally, automatically lose your case. Your sister's accused killer walks free, not because a jury found him innocent a second time, but because you personally weren't physically strong enough to risk your own life proving otherwise. So how did an entire legal system end up in a position where the outcome of a murder case could hinge on which party was more willing to physically fight? And why did anyone ever think this was a reasonable way to determine truth in the first place? Trial by combat originated centuries earlier among Germanic tribal peoples and spread across medieval Europe as one of several methods, alongside trial by fire and trial by water, collectively known as trial by ordeal. The underlying logic wasn't randomness. It was theology. Medieval courts genuinely believed that God would not allow an innocent person to lose a fight, or an oath-breaker to win one. If two people swore two directly contradicting oaths under oath before God, only one of them could be telling the truth, and a formal combat was treated as a way of forcing that hidden truth into the open, with divine intervention assumed to tip the physical outcome toward whoever was actually honest. This wasn't lawless chaos. Medieval courts developed strict formal requirements before combat could even be authorized, treating it as a serious legal procedure rather than a spectacle. Under the rules used in France, for instance, for specific conditions had to be met before a judicial duel could even be granted. The crime itself had to be certain to have actually occurred. It had to be a serious capital offense such as murder, rape, or treason. The accused had to already be under strong and credible suspicion, and every other available form of legal proof, witnesses, documents, testimony, had to have already been exhausted first. Trial by combat was never meant to be the first option a court reached for. It was designed as the absolute last resort, reserved specifically for cases where every ordinary form of evidence had already failed to settle the matter one way or another. One of the most famous trials by combat in recorded history illustrates exactly how seriously this process was treated by the people involved. In 1386, a French knight named Jean de Carouges accused his neighbor, Jacques Legris, of a serious crime against his wife while Carouges was away fighting in a war. With no way to prove the accusation through witnesses alone, and his wife's own testimony considered legally insufficient on its own, Carouges petitioned King Charles VI himself for the right to settle the matter through formal combat. The king granted it, and the case became one of the most talked-about legal events of the era. Before a massive gathered crowd in Paris, the two men fought first on horseback with lances, and when that failed to settle anything, dismounted and continued on foot with swords and daggers. Carouges, despite taking a wound early in the fight, ultimately overpowered and killed his opponent. Under the law as it stood that day, the verdict was final and absolute, treated with exactly the same legal weight as any jury's decision would carry today, regardless of any doubts anyone privately still held. For those unable to physically fight themselves, whether due to age, illness, or simply being the wrong sex under the era's assumptions, the system allowed a substitute called a champion to fight in their place. This created its own strange and predictable consequences. Wealthy or powerful parties could effectively hire skilled, experienced fighters to represent them, meaning outcomes often reflected who could afford the best available champion rather than who was actually telling the truth about anything. In property disputes especially, historians studying court records have found this frequently amounted to a formal, court-sanctioned legal method for a strong, well-connected neighbor to simply take land from a weaker one, with the fight itself providing convenient legal cover for what was really, underneath all the ceremony, an act of pure intimidation dressed up as divine judgment. This is the transferable pattern worth sitting with. Any system that claims to reveal objective truth through an ordeal, whether it's medieval combat, an outdated and unreliable historical practice, or something dressed up in more modern, more scientific-sounding language today, tends to quietly reward exactly the same thing every single time, whoever holds more raw power to begin with. The theology promised that God would personally ensure a fair and just outcome. The actual mechanism, stripped of its religious language, simply promised victory to whoever was physically stronger, better trained in combat, or wealthy enough to hire someone who was. The gap between what a system claims to measure and what it actually rewards is often exactly where the real injustice quietly lives. By the early 13th century, church authorities had already begun turning firmly against the practice. The Fourth Lateran Council in 1215 formally discouraged trial by combat as a valid form of religious ordeal, and legal systems across Europe gradually shifted toward trial by jury instead, a method that, whatever its own flaws, didn't require someone to physically risk death simply to gain access to the legal system at all. In France, the practice effectively ended as an official judicial process after the Carouges case in 1386. In England, it fell into practical disuse by around 1300 in most everyday situations, as lawyers increasingly found clever ways to steer their clients toward jury trials instead. But falling out of common use and being formally struck from the law as a legal option are two very different things, a distinction the Ashford and Thornton case would prove in the most dramatic and public way possible nearly 500 years later. Facing an opponent he had no realistic chance of defeating, William Ashford was forced to decline the combat. Under the law, that meant he lost. Abraham Thornton walked free, not exonerated by any court's judgment on the facts, but protected by a legal relic nobody had bothered to formally remove from the books. 3 things worth remembering from this. First, an ancient legal practice doesn't need to be actively used to remain dangerous. It only needs to remain technically legal, sitting quietly unnoticed on the books, waiting for the right person, at the right moment, willing and desperate enough to invoke it against someone who never expected it. Second, any system for determining truth that relies on physical strength rather than evidence will always systematically favor the powerful, regardless of what higher justification gets attached to it to make it feel legitimate, whether that's divine judgment invoked in the 13th century or something dressed up in more modern, more comfortable-sounding language today. The theology changes. The underlying incentive, favoring whoever is stronger or better funded, never really does. Third, real legal reform is often reactive rather than proactive. Trial by combat had already been effectively useless and quietly dangerous for centuries before 1818, sitting forgotten in the law books, but it took one deeply shocking, highly public case, dragged into full view of an outraged society, to finally force Parliament to sit down and formally remove it from English law in 1819. If you want more of history's strangest legal systems broken down like this, real mechanisms, real consequences, not just dramatic retellings, subscribe, because this channel is building a full series on the financial collapses and legal oddities history tends to skip over. And next time, we are staying in the world of so-called divine justice, but heading somewhere even darker and far more devastating in scale. The witch trials, where an entire continent convinced itself, for well over a century, that superstition and coerced confession could be treated as valid, courtroom-worthy legal evidence.